Any mention?
No mention. This time 10:30.
Yes, you see 1 minute less. What is the thing? This you always see.
Oh yes, yes. page 56, correct?
Yes, my lord.
So it comes down to interpretation of these two clauses.
Of that particular clause where it says utility, my lord.
Page 71, sorry.
Page 71, my lord.
Yes. The bidder participating in the bid as a sole bidder or a consortium bidder or as a lead consortium member of a bidding company and subcontractors should not be blacklisted by any government organization or regulatory agencies or government entity as on the date of submission of the bid. Bidder should submit a self-undertaking sign. So you mean to say that there's no blacklisting?
There's no blacklisting, so this clause is not applicable,
right?
my lord. My lord.
So any of your spot number 2 or yourself or anybody else,
we are not blacklisted. It comes down only to the next clause, my
lord.
lord.
It comes to the next clause. The bidder passing the bid as a sole bidder, consortium member, lead consortium member, subcontractor shall not be debarred by the MEPDCL and others utility. And others utility means like other utilities from any other corporation, or what does it mean?
My lord, that is why the definition.
Any of his subsidiaries, holding companies, as the date submission of the bid. They should submit something. Now, this is the only question to say. Because this point here says,
my lord,
MEPDCL and others, and other utility means what? If they've defined the utility in this particular tender to mean that certain Mr. MB Kuruba as given in your
bid data sheet, my lord.
Yeah, in
the bid data sheet,
page 110.
And read with Form 7, my lord.
Yeah, okay, fine, Form 7. But the thing is that if it means if the meaning covers other utilities, then we'll be barred.
Because, my lord, in my humble submission, these three parts, my lord,
are distinct.
Have to be read together, my lord. The definition of utility in bid data sheet, my lord, and Form 7.
No, what do they mean by other utilities? See, shall not be debarred by the bracket MPDCL and other utilities. Or it should be MPDCL and its utility. Other utilities means might refer to other entities and other corporations.
My lord, kindly see, my lord.
Just clarify that.
My lord, it says, my lord, MEPDCL and others utility.
Means?
My lord, in general grammar, my lord, this is not even a correct sentence, my lord.
How they mention, of course, but then you have to read into it correct grammar, read into what they mean to say.
My lord, and this is followed by, my lord, few more words, my lord. It says, or any of its subsidiaries, holding company. My lord, the word used is its.
This is a quite tricky definition. Yes. So what do you mean to say? You mean to say that the fact that this response number 2 has been debarred by this provincial company for 2 years, that's a ground taken by them that your technical bid, though feasible, because of not complying with this clause, your bid's been rejected. Simple as that. That's the core issue.
My lord, our case is that since we have not been debarred, my lord, by MEPDCL, and this clause will only apply if we are debarred by MEPDCL or any of its subsidiaries or holding companies, my lord.
It's very tricky. Yes, Mr. RP General.
My lord, the undertaking which we have given, my lord, I'll just take it lordship to the undertaking, my lord. Only 1 minute I'll take, my lord.
Yes, okay.
First and foremost, my lord.
No, okay, let him show, let him complete.
My lord, the undertaking which we gave, my lord, that lordship will find it page 502, my lord.
So financial bid being opened when?
On 14th of June, my lord.
No, financial bid.
Already opened, my lord.
502. Already opened, sorry. Yes. Oh, you found you technically and financially fit.
Technically, we were qualified, my lord. The three firms were in the fray, my lord. We were L1.
502, what do you say?
502, my lord. What is the undertaking we have given, my lord? And this undertaking was accepted by them, my lord. Undertaking for not blacklisted. We, Mrs. So-and-so, confirm that we are not currently blacklisted by any government organization or regulatory agencies or government undertaking, my lord. In terms of the tender, we, Mrs. So-and-so, confirm that we are not currently debarred by the MEPDCL or any of its subsidiary holding company.
No, it comes around back again to page 71.
And other utilities missing, my lord.
My lord, in their Form 7, the other utility is missing, my lord. I've drawn your lordship attention to Form 7, my lord. Once again, I'll draw your lordship attention, my lord. Page 139, my lord.
Short but very tricky point, Dr. Murthy.
Page 139, my lord.
Yes.
Clause
You
15 I
confirm
pointed
that the
out.
ban debarred by name
Or the
or
utility.
any is
Or
subsidiary.
any of its subsidiaries or holding
So you
company.
mean that read this together with the earlier
Yes,
with the defining
yes,
clause?
yes, my lord.
Definition of utility.
Yes, okay. Yes, Mr. Advocate General. Yes.
Yes, my lord. First and foremost, Mr. Miller, that writ has been filed by the petitioner, who is not the bidder.
Who is not? Who's not what?
The bidder in the bid, Miller. It is a company. The petitioner has not submitted the bid. It's in individual capacity.
What do you mean by that?
Bid has been submitted as consortium, and
Okay.
consortium is not the free lottery.
That's why this court asked, like, not agree. Why? Yes, okay.
Yes, and Lordship has rightly put the question to the petitioner that the consortium partner is not agreed with the order. It is the petitioner is not the bidder before the MEPDCL. Petitioner has not submitted the bid in its individual capacity. So therefore, the writ on behalf of the petitioner, which has not participated in the tender, is not maintainable. That is on the issue of maintainability by a partner to the consortium, and the other consortium partner is not aggrieved by the order passed by MEPDCL below.
Yes.
That is the first aspect of the matter.
Yes.
Second aspect of the matter is, that admittedly the fact that consortium partner, BCITS, if I am not wrong, has been banned for a period of 2 years
Debarred.
by the other utilities.
Yes.
And has been debarred for a period of 2 years. This fact has been suppressed.
Yes.
The petitioner or consortium partner, which is not before your lordship, have made an attempt to do the hair splitting
Two?
in the interpretation of the contractual of the tender terms. Like what they are, in my humble submission, what they are trying to do is, Lord, is trying to interpret the terms of the tender like a statutory provision.
Okay.
This is the interpretation given by the employer,
Yes.
and the employer's interpretation, in my respectful submission, is not perverse or not against the terms of the contract. So first submission which I said, that the bidder is not before your lordship. The consortium partner cannot be agreed because it has to be by both the partners.
Yes.
Consortium, so far as tender is concerned, legal entity, and therefore legal entity is not challenging the order passed by the MEPDCL holding that the bid is non-responsive.
Yes.
Second fact is, my lord, that they have not approached the whole case or to the authority with clean hand.
Suppression.
They have suppression of the material fact, and utility has banned them for a period of and it's not, if your lordship will see the number of pages devoted by utility in banning them, my lord, is more running into the 100 pages.
It's the next year.
505 to 598. 505 to 598, my lord, an extra R. And if your lordship will see pages after pages,
5052.
everything has been 5098. And then your lordship will see 597.
It deals with debarment, the entire thing.
Debarment. Yes, for two years. Now what my friend is arguing.
597.
Is that, look, I have been given yes, your lordship. 505 to 598, 507, 597. Bottom paragraph, last paragraph of page 597.
Yes.
Though the financial punitive action was taken under the provisions of the agreement as per UP Power Corporation, but from the above facts and analysis, it is evident that requisite improvement did not reflect in the working culture of the firm, And keeping this fact in view, and also to save the corporation from fiscal and financial loss in future, Messrs. BCITS so and so in consortium with so and so is debarred from taking participation in all tender works of PUBBNL Varanasi for a period of 2 years from the date of issue of the office memo and in the interest of the corporation.
This was issued this year only, January.
Yes, this year, and this fact is not placed before us. And I put a question to myself, if the fact was brought to my notice, and when I come to know that, look, there is a
How was it brought to your notice by the other bidders?
Yes, my lord, I got the notice, and that is why your lordship will see the clause 71. In fact, your lordship will see page 11 of the writ petition. Page 11 of the writ petition.
Yes.
And your lordship will see page 9, 10 where the clauses are quoted.
So we don't consider blacklisting. We only consider this other clause regarding the.
Yes, your lordship, kindly see, there are two clauses, there are two
parts here.
If at any stage of the bidding, now your lordship, debarment and blacklisting. If the question is whether within blacklisting, debarment will subsumed or not. A company which is blacklisted is necessarily debarred also, Miller.
Yes.
A company which is not blacklisted, it will not be debarred. So what might...
No, the only case is this, Mr. Advocate General, is that the definition, I mean the stipulation in your criteria is that they should not be, they should not be debarred by utility, which they say that it means utility of the MBPDCL only, and that in the Form 7 also, in continuation of that clause, it speaks that way only. That's the only thing. So undertaking is given that you're not been debarred by any utility or MBPDCL, so it means that the bid should be all right. That's the argument. Now, how do you counter that? Because the Form 7 speaks otherwise. Even if it's not to be independent statute, but if once the tender conditions are laid down, I mean, it's expected that we all abide by the tender condition. Yes.
Yes, sir. So these two aspects are there. One is that the interpretation given by my learned friend as to the...
No, that is a serious hurdle they have to cross. That regarding that, why the consortium has not come.
That is one aspect, Second aspect is that what they are saying, I have been debarred and not blacklisted, therefore I am eligible.
That second ground, but the first ground is very... why consortium has not come?
My lord, yes, my lord. The other member of consortium is before your lordship, maybe as a respondent. My lord.
That they are not challenging the order. Respondent is not aggrieved by my order.
No, other member of consortium. I mean, then if you applied for the tender jointly as a consortium, it stands to reason that even if any actions taken against your consortium, against your bid, that you stand together.
Listener is not aggrieved. Listener is not a company which is coming, has submitted the bid. So on this ground alone, I need not take your lordship, but I just, so far as the second aspect is concerned, my lord, kindly see the clause. Clause is also...
Yes, page 11.
Yes, lordship. Clause 11, or I can take your lordship. If at any stage of the bidding, any order ruling is found to have been passed in the last 1 year preceding bid submission, deadline by competent court of law, or by any appropriate commission, or any arbitral against the sole bidder, lead bidder, any consortium member, or its affiliate for breach of any contract awarded by government department, shall liable to be rejected. Breach is there, I have shown the order.
Yes.
All bidders shall conform to the accordance with Form so and so, and affiliate in case of such ruling is duty of the bidder to inform utility for the same during bid submission. Where is the duty? Now they are in breach of the duty, and what they are arguing before that, look, I am in breach of the duty, but extraordinary jurisdiction of this honorable court should come in their rescue, my lord. That is their argument in my humble submission. Now, quote, my lord. Eligibility. Bidder participating in the bid as sole bidder or a consortium member or a lead member of bidding consortium and its subcontractors should not be blacklisted by any government or regulatory agency or government undertaking as on date of submission of bid. Bidder should submit itself an authorized signatory for same as the format prescribed in so. Bidder participating in the bid as sole bidder or a consortium or lead member shall not be banned, debarred by or other utilities, what they are trying to canvass and argue for your lordship is that it should be taken as constricted meaning, narrower meaning, and meaning which should favor the bidder who has been debarred by a utility company in Uttar Pradesh. And now what is being disclosed for the first time, there is no disclosure in the petition, that decision is under challenge before Allahabad High Court. So therefore, as on today, the partner is debarred, and it is debarred by other utility. And that fact has also not been disclosed, Milord. So if it is debarred by other utility and this decision is of
now have you declared the successful bidder?
Milord, that is
as per this existing consortium in the fray.
For that I have to take instruction, Milord. So far as on today, Milord, if your lordship will see, we have issued the so cause at 602, Milord.
They have replied to it. You have replied to it.
Yes, Milord. Yes. Kindly see the clarification also, Milord. 3rd July and the
602.
Clarification is, yes, Milord. 604 is the clarification.
Yes.
This is the clarification which is, so Milord, once I discover that your utility partner is, your partner is debarred.
No, the case limits to this only, that we are not debarred by MPDCL, so that's it, we are eligible, simple as that. Yes, and your conditions, other utilities, one utility is that...
If your lordship has seen, your lordship will lean in favor of the party who has truthful in disclosure. A party who has not been debarred. Milord, I will be giving the contrast to this bidder who has been debarred, and your lordship have seen 100 pages of the order passed where each and every state utility company has held that financial punitive action. So whether I can trust my interpretation, Milord, if your lordship will see, it is the interpretation of the employer. If there are two views, if I take my friend's argument, two views are possible, Milord, even assuming that view which is taken by employer, my humble submission, should weigh with your lordship. And your lordship, what is the urgency which they are pleading, Milord? 19 September is the order passed, Milord. And they are coming now almost after about a month, Milord. Milord, I rely on very recent judgment of the Honorable Supreme Court, Milord. While explaining the terms of the contract, Milord, the judgment of 19th May 2023, my friends will have a copy.
Same judgment was placed in another matter, yes.
There are certain issues, Milord, which 48, Milord, I seek your lordship kind attention to paragraph 48, Milord.
Yes.
This court, being the guardian of fundamental rights, is duty bound to interfere when there is a arbitrariness, irrationality, malafide and bias. None of them are pleaded before your lordship. However, this court has cautioned time and again that court should exercise a lot of restraint while exercising their power of judicial review in contractual or commercial matters. Court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is without. So clear, my emphasis is clear-cut. One must remember that due to many public sector undertakings compete with the private entities, the contracts entered into the private are not subject to scrutiny under writ jurisdiction. No doubt bodies which are stayed within the meaning of Article 12 of the Constitution are bound to act fairly and are amenable to jurisdiction of superior courts, but this discretionary power must be exercised with great deal of restraint and caution. Court must realize that limitations can cause havoc with this needless interference in commercial standpoint. In contracts involving technical issues, the court should be even more reluctant because of most of us in judges who do not have the necessary expertise to adjudicate upon technical issues. My lord. The court should not use the magnifying glass while scanning the tenders and make every small mistake appear to a big blunder. In fact, court must give fair play in the joints to the government and public sector undertaking in the matters of contract. Court must also not interfere where such interference will cause unnecessary loss to the public sector. And then your lordship will see paragraph 52.
That is the same judgment that Kota Dal case, I think.
Yes, Your Lordship, and my lordship has applied that judgment, Lord, in my court.
Learned AG succeeded in that one.
Yes.
Ordinarily,
Expert now in-
this is the latest judgment, Lord.
Yes.
Ordinarily, a writ should refrain itself from imposing its decision over the decision of the employer as to whether or not accept the bid of a tenderer unless something very gross or culpable is pointed out. The Lordship has to see whether my opinion or my view is gross and culpable. The court ordinarily should not interfere in matters relating to tender or contract to set at naught the entire tender process. At this stage, when the contract is well underway, would not be in public interest. Initiating a fresh tender process at this stage will consume a lot of time, lost of public executive to the tune of the financial burden implicated on the that the state may have to meet the court's right to a fresh notice should not be one of the guiding factors of court to do. My argument before your lordship, in the light of this ruling, is that the interpretation which the employer has given me, in my humble submission, is a plausible interpretation. And if your lordship will see the attendant circumstances, one, no disclosure. Second, fact the department is there. Third, we have issued so-called notice, we have given opportunity, and then thereafter we have divided, my lord. So therefore, my humble submission, I will file a detailed reply, etc., my lord. But it is a case where, my lord, the process, what my friend is saying at this point of time is saying, my lord, this is my humble submission, it's not no case of saying, my lord, because the entire system has started in December of.
What is the value of the contract?
It's out of 500 crores.
500 crores. A small amount.
For MECL.
Yes. You have been muted.
I think so.
Yes. What's he doing?
Ajay, I think there's something wrong with the audio.
From where?
Watch, I'm not sure.
From Delhi. Mr.
just
Secretary
check.
General, something wrong with the audio from your end. Oh, a senior counsel, okay. Oh, not by design, but by accident. Yes.
My lord,
What
only
did
two
you
things
have to say?
I wanted to point out, my lord.
Yes.
My lord, the notice.
See, what disturbs the court is on the first ground itself.
My lord, I'll try to answer that.
As a bidder, you have come as one entity, correct, consortium.
My lord.
But coming before the court, the same person should come, the same entity should come.
My lord, there are two reasons.
How can you split it up?
My lord, there are two
And
reasons.
make them the respondent and you become the petitioner.
I'll
You're not a pro forma, you become as a
I'll answer
full-time
that.
respondent.
I'll answer that, my lord. My lord, the lordship kindly sees, my lord, the notice for clarification was issued to us, my lord, to the lead partner in the.
That is between you. The thing is that
No,
your bid, the very fact your bid was in a consortium, right? You're the lead bidder.
My lord.
They're the secondary bidder. Together you came like to put in the bid, right?
lord.
And then okay, fine. That is the most important thing that has gone on record. Now, when you come before the court, also it is only natural that you should come as a consortium.
My lord, kindly see.
Why do you need authorization from two companies? You mean that's difficult?
My lord, the notice for clarification was issued to lead partner to us, to the petitioner, my lord, and even the debarment order, my lord, the impugned order is only issued to the lead partner, my lord. Kindly see, my lord, the impugned order, my lord. Page 504 is addressed only to Aprabha, my lord, who is the petitioner, for lordship.
Page 5?
504, my lord. The impugned order, my lord.
Yes.
Is addressed to us, and this is the order we are challenging, my lord.
No, but
The connotation of challenging this is also, my lord, why this notice, this impugn order issued only to us and why not to the respondent number 2, my lord?
You're the lead bidder.
So, my lord,
That is why.
my lord, if
And
you are accepted as lead bidder,
you've
my
been
lord,
informed, and they said that, look, as your consortium partner, has been devoured by so and so.
For a very different reason for some other contract. You're not even aware.
She wouldn't pro forma party. If you're on the same page.
there is a party, my lord. We can file an application for making them as a pro forma rather than a regular respondent, my lord. But in my humble submission, my lord, only that consideration, that is a rectifiable aspect, my lord.
What other submission do you have?
My lord, our main submission is that we were technically qualified, my lord, and there is no concealment of fact, my lord.
You only think other utilities. That's the only.
Yes, my lord, and that is how we interpreted, how we gave our undertaking, my lord, and what was accepted by them, my lord, at that point of time. They accepted it, my lord. They technically qualified us. They opened our financial.
No, undertaking accepted. Now, what have they submitted? Accepted because the fact is suppressed.
My lord, no fact is suppressed, my lord.
Why not suppressed?
No fact is suppressed, my lord. The Form 7 only says that are you debarred by MEPDCL or its holding company or its subsidiary. We say that we are not debarred. Till today, that is the truth, my lord. That we are not debarred by MEPDCL or its subsidiary or its holding company, my lord.
Right. Only that point is there. Anything else?
My lord, basically it revolves around that part only, my lord. While reading that particular clause 4, my lord, together with
Form 7.
Form 7 and the definition of utility, my lord. And after they accepted everything, my lord, they technically qualified us, we are L1. And after we are L1, my lord, they go on a fishing expedition to find out how can they throw us out.
Alleged malafide here.
It's an apparent case of malafide, but there is something behind the scene, my lord.
No, but something behind the scene, it should be some like contrived, not something which stares you in the face. If it's contrived, yes, or some like, they put 2 and 3 plus and comes to 6 or something and they debar you. Yes, but in this case, it's clear that there is a standing debarment order against your consortium partner. He has not come before the court here also,
but not by
to assail that. In fact, it would have been in his best interest that he comes straight away. And after the thing came, said, look, now you are the one, who's fighting for him. That's the thing. Very difficult for the court to pass any kind of interim orders. We can examine it.
My lord, only what I am praying, my lord, that we can have instruction, we can talk to them, that is rectifiable, my lord, even at this stage. My lord, what I pray, my lord, let them file an affidavit, because the interpretation, they themselves are giving 2 interpretations. At the first round, my lord, they accepted this interpretation that the utility will only mean MEPDCL. They accepted our undertaking, my lord. It is not that we have violated any condition of our undertaking.
No undertaking is accepted, my lord. No
undertaking was accepted. We were technically qualified. Whether not awake, my lord, when they were technically qualifying us, my lord.
What is the difference in the financial bit, yours and the others?
That they'll be able to say, my lord.
There is nothing, there is no amendment, not a single line, not a single word in the whole.
And completed his class 2 training in 2016.
Okay.
Now, my lord, on 17th November 2016, he completed his training. The certificate date is 17 November 2016. 18th November 2016, my lord, he was posted to Chardwar, Assam. Chardwar is a place. His class 2 training was held in Shillong, my lord. He was posted to Chardwar, Assam, and after posting in Chardwar, Assam, my lord, the respondents are taking the service from the petitioner with regard to the task of SKT engineer.
That will not entail anything, yes. Then?
My lord, I'll try to satisfy your lordship on that. He has been serving as an SKT engineer since that time.
For how long? From which year?
From 2016, my lord. It's more than 7 years now.
How old was he that time?
My lord?
How old was he that time?
My lord, 36 minus 7. So it comes to 29, 30 years old, my lord, at that point of time. So, my lord, the point of time when he started serving as an SKT engineer was 29 or 30 years, which falls within the eligibility criteria.
When did you do the recruitment for these 8 vacant posts?
My lord, for this 8 vacant posts, the first advertisement was issued in 2021. 12 November.
That time you already...
My lord, just a second, if I may pause here. On 12 November 2021, one advertisement was issued, but the selection process could not be concluded due to reasons known to the respondents. And subsequently, now they have come up with another advertisement on 15th of June 2022. The second advertisement. Against the second advertisement, the petitioner applied. He applied for remusteration on 21/6/2022, immediately after the issuance of advertisement. On the same day, my lord, he executed his willingness certificate also, that he is willing to serve in the post.
Okay.
And just after 4 days, on 25/6/2022, the major adjutant forwarded the petitioner's application to the Directorate General Assam Rifles. Now, my lord, for a period of 2 months he had been waiting. On 12/8/2022, the respondents have come up with a select list. Now, my lord, though the vacancies are 9, but the select list which has been published by the respondents fills only 8 posts. And out of these 8 posts, my lord, there is not a single person who has completed this SKT engineering training course.
You meet the respondents here.
No, my lord, we are not aggrieved by that. We are concerned with my post.
That post has got your name on it. That's what you
My
feel.
lord, one post is there. It is still lying
your name's
vacant.
already there. That
Yes, my lord. One post is still lying vacant. So, my lord, now coming to the legal points, my lord, the very first point which I would like to...
Where the grounds of rejection? Only that you didn't have to have the age.
Yes, my lord, only overage. In the affidavit in opposition, they have come up, and the only ground of rejection is overage. Now, my lord will take into consideration the first and foremost, my lord, the point which your lordship had just posed, that what was your age at that point of time in 2016. So, my lord, I have been serving since 2016, and that is why I rely on this judgment passed by the Honorable Guwahati High Court, my lord. If your lordship kindly takes up paragraph 17, the last page, my lord. Paragraph 17. It does not relate to remuneration, my lord, but the principle of law will apply in my humble submission in this case.
Yes.
If the petitioner is found to be fit in the review medical examination, my lord, in this case, instead of the review medical examination, all the other eligibility criteria would come. Then the respondents would have to consider appointing the petitioner in as much as the petitioner was within the permissible age limit at the time he joined.
Thing altogether, MS Agarwal.
My lord,
Different in the sense that at that point of time, if the advertisement had been issued and you're serving,
that is what, my lord.
You're not serving at the time the advertisement was issued.
My lord, I have, and I'm still in service.
No, were you within the age when the advertisement was issued? Were you within the age of consideration?
My lord,
35.
My lord, there comes the entire matter.
Yes.
Because, my lord, I am serving as SKT engineer since 2016.
When the advertisement first come out?
My lord, 2021.
Yeah, what age? What is the age then?
My lord, 2021, I was 35.
Yes.
I was 35, my
Then
lord.
this was cancelled. Nothing happened to this 21 selection, correct?
My lord, because
then
of the
22 was the
respondents.
subsequent selection, and you were already over age by that time.
So, my lord, it is
Simple
not.
as that.
My lord, here comes the question of legitimate expectation.
Legitimate expectation, okay. Right, you have legitimate expectation.
My lord, not
but whether
just-
the legitimate expectation is
there is-
based on any substance,
My lord,
anything. With Dr.
legiti-
Mozika, I'll take some time that hearing.
Your lordship, he'll take some time, your lordship.
My lord, legitimate expectation, if your lordship kindly sees paragraph 16 of this judgment, my lord. Your lordship is well aware about legitimate expectation, and I need to go deep into it. Now, lordship, it may be in paragraph 16, my lord. Lord, here there was a change in policy. The same applies here in this particular case as well. It may be indicated here that the doctrine of legitimate expectation imposes in essence a duty on public authority to act fairly by taking into consideration all relevant factors relating to such legitimate expectation. Within the conspectus of fair dealing in case of legitimate expectation, reasonable opportunity to make representation by the parties likely to be affected by any change of consistent past policy come in. Now, my lord, the past policy was, I am the only person who was sent for training. I have been serving in that particular post for 7 years. For a period of 7 years, I have always been given an assurance that as soon as the advertisement is out, you will be...
May I be certain your pleadings?
Yes, my lord. I'll take that to you. I'll take your lordship to that.
You have 186.
I have pleaded that, my lord. Paragraph 9, my lord, page 7. I would like to read paragraph 8 as well, my lord. That thereafter petitioner was sent to Charidwar, Assam in the year 2016-17, and at Charidwar the petitioner was allotted to perform duty of SKT engineer along with his GD duty, that means from 18/11/2016. Although he was performing as GD as well as SKT engineer, but he was not appointed as SKT engineer since no post of SKT engineer had been created till that time. However, he completed the course of SKT engineer, and as such the commandant of the writ petitioner asked him to work as SKT engineer and assured that whenever the post would be created, he would be appointed in the said post. That on such assurances the petitioner had legitimate expectation that he would be absorbed as SKT engineer when post of SKT engineer would be created, and so the petitioner continued performing duty of SKT engineer, whereas he was receiving salary only for rifleman GD, as no formal appointment could be given due to aforesaid formal vacancy. My lord, this proves that there is no fault of the petitioner in this, my lord, in my humble submission.
Yes.
And if I may draw your lordship's attention to paragraph 15 of my writ petition, page 10. That the petitioner, having all the requirements as per both the advertisement aforesaid and as such in his application, the petitioner specifically stated that he has completed 16 years of
So you wanted to
service.
see that, see, as per the policy decision, that they should be 35 years, and under age of application, as per the affidavit, you see, you're 36 years, 4 months, and 9 days old.
My lord, I have mentioned the exact age in this particular paragraph, paragraph 15. However, no post.
And these recruitment rules are statutory provisions.
My lord, there is no specific rule, my lord. It is only in the notification that this advertisement that the eligibility criteria has come. Your lordship has already seen on legitimate expectation. Now, my lord, I will.
No, you're saying that because you're storekeeper technical for all those years.
Yes, my
that
lord.
means that gives you a right to claim
Not
the
a
post,
right, my,
remuneration.
not exactly a right, my lord. Legitimate expectation, and secondly, my lord, if I am being prejudiced due to no fault of my own.
Now
then
they have denied that you served as the SRT technical. Huh?
lordship will kindly see just this last paragraph 22 of this Dipali Gunse judgment, my lord.
Doesn't matter, Ms. Arwal. Where's Dr. Mosika? We'll dispose of the matter.
Lord, at least if there is only one person, my lord.
They can be
At
in
least
consideration
on
also. It's not a
sympathetic
question
grounds,
of-
my lord. It's been a number of years that he has been serving as SKT engineer on the assurance that he will be
deny
appointed.
that.
On the assurance that
They
he
say
will be
you never serve
appointed.
as SKT engineer.
My lord, we have categorically denied that in our rejoinder. We have categorically denied that.
You met all other criteria. They
Yes,
admit
my
that,
lord.
except the age.
Just
So what to do?
that to just 1 year, my lord. 1 year. My lord, it may not be set as a precedent, but at least the petitioner should not be left in prejudice in this manner, my lord. as a matter of consideration, the petitioner may be appointed, because issuance of advertisement is not the petitioner's fault, my lord. Why did they send me for the course in 2006, 2010 and 16?
The main thrust, I think, if I can see from evidence, that each criteria cannot be overlooked.
My lord,
Simple as that.
why did they send me? They had sent me for the training.
The other
They
people is
have
sending
been-
them after selection.
After
to obtain-
selection, my
obtain
lord. But then eligibility criteria provides that they should be qualified at the time of selection. They themselves are overruling the.
There's no additional pay for this to keep it technical, correct?
Sorry, my lord.
There's no additional pay. You're not entitled to additional pay, correct? Same pay as you're enjoying now.
Yes, my lord.
Then
My lord, it's not about the pay. It's about the post, my lord. Being a normal rifleman GD and performing the job of an SKT engineer for the past 7 years, my lord, in terms of experience, in terms of skill, in terms of qualification, in all other fields, my lord,
I've understood your case totally.
in all other fields, and that too, my lord, due to no fault of the petitioner.
Okay, you are you here in Shillong? We'll dispose of the case since
Maybe tomorrow also, my lord. I'm here tomorrow as well.
you're here, but the court's not here. So
Oh yes, my lord. I forgot that.
yes,
I'm here, my lord.
this is a matter for further hearing after 1 week.
My lord, if a fixed date could be
That
given,
you take from the court master.
my lord.
That you can dispose it of now only anyway.
At least, my lord, if as not as a precedent, my lord.
Rules are recruitment rule 2015.
My lord, not as a precedent, my lord.
And I think they deny that you anyway. You let them answer. Yes. Here for the petitioner here.
Yes, my
Yes,
lord. I'm
yes,
here
yes,
for the petitioner. I have come before this honorable court against the cancellation of the tender process. The last, if I may just take your lordship first to the cancellation order. It's the last page of the petition. Lord, Mr. Sahai is supposed to appear, but he's for the respondent.
Where the fiscal counsels assisting
My
him?
lord,
that
Miss Kolni also, I had seen her, but I don't know.
day. He's come.
MBCL matters.
Sure, it's supposed to be Arvind's matter, Lordship. Just
In fact, this matter was also parted along with this Pramod Patra matter, my lord, just the matter which I argued before this. Both the matters were on the same day.
There's no connection between these two matters. This is also legitimate expectation.
My lord,
This is also legitimate expectation that we sell the contract.
it is, my lord,
contract
but
was-
not just legitimate expectation, my lord. Your lordship had put a query to me.
What is the query?
The query was, my lord, whether this November 2020 regulations of the World Bank, because, my lord, this particular project, if your lordship comes to the NIT, page number 16, my lord.
$60.
16.
Yes, Mr. Sai. You ready?
Yes, Your Lordship, I'm ready.
Yes.
Page number 16, my lord, paragraph 2. Bidding will be conducted through national open competitive procurement using request for bids as specified in the World Bank's procurement regulations for IPF borrowers, November 2020. The procurement regulations, my lord. The
Yes.
procurement regulations are very important in this matter, my lord. Your lordship had posed the query that whether the procurement regulations are mandatory. My lord, to that effect, I could not get a judgment, but in my
Where is that? Where reading?
paragraph 2, my lord, page 16.
Yes.
It will be conducted as specified in the World Bank's procurement regulations, my lord.
Yes.
Now, my lord, World Bank procurement regulations clearly provides the manner in which a bid or proposal can be rejected. If I may take your lordship to page number 566.
Let's go to your prayer first. I've forgotten about the case.
My prayer is simple, my lord. My only prayer is to continue the tender process from the stage where it has been stopped. Technical bid was opened, my lord. In the technical bid, the petitioner was the only bidder who qualified. That was in January 2023. January 2023, the technical bid was opened, my lord.
That's it, 1/5/2023 order. Where's the impute order?
1/5/2023 is the last page of the petition, page 577.
Page 577.
577, my lord.
Okay. What's the reasons given?
No reason mentioned in the letter, my lord. It simply reads, this has a reference to the tender submitted of the above subject. The management of Meghalaya Power Generation Corporation Limited decides to cancel the above tender. We appreciated your participation in the bidding process.
Can a manifest issue for them to continue without us, the court, knowing what are the commercial and the financial implications
My lord,
and the requirements?
since the MEPGCL has itself in the NIT undertaken to carry out the entire bid process according to the 2020 procurement regulations.
Yes, excuse me.
My humble submission is that the regulations need to be followed in spirit, my lord. In letter as well as in spirit, my lord. Page 566, my lord.
Yes. 566.
566.
Yeah, that I've seen. 567.
Yes, my lord. Your lordship will remember 566, not 566.
Rejection of bid proposals.
Yes, my lord. So if I may read clause number 5.58. 5.58 and 59 are relevant. 5.58. Rejection of all bids or proposals is justified for contract subject to prior review with the bank's no objection when number A, effective competition is lacking. Number B, all bids or proposals are not substantial. My lord, B, C and D do not apply in the instant case because in the affidavit in opposition, the respondents have come up with a categorical stand that the tender has been cancelled due to the fact that only I have qualified in the technical bid. So they are cancelling the tender process on the ground of lack
Only
of
one
effective
bidder.
competition.
I mean, you
Now, my
there's
lord-
only one who passed technical bid.
Yes, my lord. Now, my lord, if I may take your lordship to 5.59. Lack of competition shall not be determined solely on the basis of the number of bidders or
Yes.
proposers.
Now I remember, yes.
Even when only one bid or proposal is submitted, the process may be considered valid if, number A, the procurement was satisfactorily advertised. My lord, with regard to point number A, my lord, my submission is this particular bid, the tender, the last date for submission of bids was extended on 3 occasions, my lord. So this proves that the procurement was satisfactorily advertised.
Right.
Number B, my lord, the qualification criteria were not unduly restrictive. My lord, the qualification criteria has been decided according to the work which was being allotted. So, I have qualified in the technical bid on the basis of those criteria. These criteria are definitely the ones which are important for the work. That is not disputed, my lord.
You're only qualified bidder.
Yes, my lord. In fact, it is the respondents who have come up with this particular plea in the affidavit in opposition. Number C, my lord, prices are reasonable in comparison to market values. Now, my lord, clause C will come into force.
Excuse me, yes.
Clause C will come into force only when the financial bid will be opened, my lord. Until and unless the financial bid of the petitioner is opened, the comparison cannot be made as to whether the price quoted by the petitioner is reasonable in comparison to market value. My lord, I am not claiming that the work order should be given to me or the tender should be awarded to me. My only humble prayer is to open the financial bid in terms of these particular policies which have been admitted to be undertaken by the respondent authorities. They say that they will be following these procurement regulations. So, my lord, if the procurement regulations say that lack of competition does not mean just there being one bidder or one proposer, then, my lord, they are to follow this clauses A, B and C also. My lord, advertisement not disputed, unduly restrictive, my lord, the work, the conditions in the tender were according to the work, because it is a dam project, my lord. So the criteria has to be according to that only.
Yes.
If even after 3-4 extensions, if people are not participating, or from across other states they are not participating or whatever, that cannot be a ground, my lord, to stop me. I am not claiming a tender, the tender to be awarded to me. My only humble prayer is to continue with the tender process, my lord, because after the technical bid, after submission of my bid, I had prepared everything, my lord, so that the work can be executed within the time frame given in the NIT.
Only one thing, come to the broader picture. You have to show this court that you have a legally enforceable right. That's the only thing.
The right is these particular regulations. On the basis of these particular regulations only, I am claiming that it may be carried forward.
How have you been discriminated against?
My lord, the tender has been cancelled after a period of 4 months, my lord, from the date of opening of technical bid.
Now the thing is that your bid is considered, you're the only successful bidder.
Yes,
Correct.
my lord.
So legitimate expectation is that you should be.
After financial bid also, my lord, they are not exempted from nobody is stopping them.
Only one thing, see, you only have surface score is what is your enforceable legal right in this contract. That's all.
Yes, my lord.
That's the only thing.
In this particular.
So how can you twist the arm and compel them?
My lord, they will at least check the
Suppose
financial.
you go to a shop, you want to buy something. Okay, you want to buy maybe some commodity, and the price is maybe 10 rupees. You say take 20 rupees, and the shop says no, like for reasons I can't sell. There's only one piece left. Something you twist the arm of shopkeeper and say sell that to me 20 rupees.
Lord,
so I'm the highest. I'm giving the highest price.
My lord, neither I can compel the respondents, but the only thing is the reason. There was no reason in the letter. They have come up.
Yes.
They have come up with a reason in the affidavit in opposition, and that too, that particular ground taken in the affidavit in opposition of lack of competition is dehors these procurement regulations of 2020, and these procurement regulations of 2020 have not been forced upon the respondents by the petitioner or any other person. The respondents have voluntarily taken these particular regulations as to be followed by them. So, my lord, I am only on the regulations.
Where you said where is that you're a successful bidder in a writ petition? Where is that?
My lord, at the time of filing the writ petition, I was not even aware that I am the only technically qualified person.
Or are you the only bidder, or you're an only technically qualified bidder?
Only technically qualified.
How many bidders were there?
2 bidders were there. They have stated in their affidavit in opposition.
Okay.
2 bidders were there, my
Where
lord.
do you say that you're successful?
My lord,
And you'll be successful, of course.
My lord,
Since the only bidder, yes. Where is said that?
para 32, page 23.
That's the only thing you see.
Para 32, my lord. 4th line. However, due to qualification of only one bidder, the tendering was cancelled and decided to re-tender the work to have a competitive bidding, and no mandamus can be granted in favor of the petitioner.
And so you say that the World Bank directives say that even as one bidder, go ahead.
Yes, my lord. If these 3 criteria are being fulfilled.
Yes, Mr. Sai.
Yes, Your Lordship.
What legal? Yes.
Your Lordship,
What legal enforcement right do they possess?
Correct. Lordship is, in fact, the only fundamental query and the only obstacle that the petitioner has to cross is to establish before your Lordship that there exists a legally enforceable right. In tender jurisdiction, your Lordship knows that the scope of judicial review is extremely limited, and only when there is demonstrable arbitrariness or malafide, which is not the case in the present situation. Only then, in the rarest of rare cases, can there be an intervention, if at all there is one. Here, even the own stated case of the petitioner is that the guidelines of the World Bank enjoin the corporation to have proceeded with a single qualified tenderer.
Yes.
And that, in my respectful submission, your Lordship, is incorrect. I'll demonstrate that by straight away showing page 566. 566. Clause 5.58.
Yes.
5.59. My apologies. 5.58 also, sorry.
5.58.
Rejection of all
Effective
rejection
competition
of
is
all
lacking.
bids. Yes, effective competition is lacking. 5.59. Lack of competition shall not be determined solely on the basis of number of bidders or proposals. Even when only one bid or proposal is submitted, the process may be considered valid if. I am placing emphasis on the term may be considered valid if the procurement was satisfactorily advertised, the qualification criteria were not unduly restrictive, and prices are reasonable in comparison to market values. What I submit, your Lordship, is that these factors are factors that may, in the discretion of the employer, be taken into consideration. So, for instance, if we would have gone ahead with this bidding process with a single qualified bidder, and there was a challenge laid to that process, then I could have taken shelter of these clauses to protect such an award by saying that I had the discretion to award it to a single bidder. But the discretion to award includes within it a discretion not to award. So the only issue, therefore, is that whether the discretion has been fairly and justifiably exercised in the present case. And that, your Lordship, will find from page 16.
16.
From page 16 itself, 16
Of the
page 16 of the paper book. Yes. Why I say this is Lordship will understand the scheme in which this is progressing. Why the discretion is entirely ours.
yes.
It's apparent from point number 1 and 2. The government of India has applied for financing from the World Bank towards the cost of dam rehabilitation and improvement project phase 2, trip 2, and intends to apply part of the funds to cover eligible payments under the contract for construction of works as detailed below. Bidding will be conducted through a national open competitive procurement using RFPs as specified in the World Bank procurement regulations for IFP borrowers November 2020 and is open to all bidders as defined in the procurement regulations. So now your Lordship will find that there is a financial grant being made to the state by the World Bank, and that financial grant is governed by the terms and conditions under the World Bank's procurement regulations. So, if at all this would be a violation of the guidelines, which in my respectful submission it isn't, then the impact would be on the grant itself. So the World Bank can say to the corporation that, look here, you have violated the terms and conditions, and therefore we resigned from you the entire grant, the financial grant that we have given to you. But a tenderer may not be able to enforce these regulations as is sought to be done. Because these are the conditions of a grant, a financial grant, pure and simple. The test therefore still remains is because the cardinal principle of tender jurisdiction is that an employer has free play in the joints.
Yes.
And number two, your lordship will find that this is a dam rehabilitation and improvement project phase 2. This is not a simple supply contract for certain food products or a simple procurement contract for certain school stationery or something of the sort. This is a important project which involves highly technical and skilled work in the nature of dam rehabilitation. So therefore, it stands to reason that there should be more competition.
So what have you done? Have you opened a competition again or stuck where it is?
It is
At the moment, Lordship, it is my instructions are it is at the same stage. It is at the same stage. We'll have to put it to retender.
There's no orders prohibiting
So,
that.
no, my lord.
There is no
There's-
orders prohibiting that. There is no orders but your lordship knows that once a tender is opened, we disclose the pendency of a litigation. Then it again sometimes disincentivizes bidders to participate.
But is the rates of the
so-
petitioner known to you now?
No, the rates of the petitioner are
Then
not
you-
known,
then-
but the
then you-
rates
then
as,
That's
take
the
part-
point, my lord. That's the point.
as your
My lord, taking part is a separate issue.
You take part again.
Mr. Sahai may complete his submissions. Then there's just one point
No,
which
no.
I would like to clarify.
I don't think you need any submission. That
Yeah.
is enough. Yes. Yes. Anything else to
yes,
say?
and yes, your lordship, and the only other aspect of the matter that now the tender jurisdiction has been further narrowed by various judgments of the Honorable
Yes.
Supreme Court. Now the Supreme Court says that even when there is apparent arbitrariness, even then you should relegate the bidder to seek damages. But one must not interfere in the tender process. So this is how narrow it has come from Tata Cellular to Uflex now. We are standing at a position where even if a bidder has wrongfully been denied a award of a
Yeah.
tender, then the remedy lies in money terms. That they should be relegated to seek civil remedies and should seek, because essentially where the shoe is biting the tenderer is that the tenderer says that I have put in place man and machinery in anticipation of award of this tender. So therefore I have invested monies and therefore those monies are now wasted expenditure, and it is only because you did not go ahead with the tender. So the shoe pinches only there, and it can be adequately remunerated in money terms should the tenderer so choose to go down that route. But as I demonstrated, Lordship, first, the guidelines on which reliance is being placed, those guidelines in any case, they completely protect the discretion of the employer. They do
That's
not
the,
mandate
that's the only thing.
that
Come back
I
to the
shall.
basic point is like I keep asking, how do you have a legally enforceable right? They are
that
the
is my
owner. They are the
only
owners
point.
of the contract of the project.
My lord.
And if you see all judgment, there's a recent judgment of this
Yes, ma'am.
of this court also, where only damages have been given because it was a clear case of arbitrariness. There's a judgment. I think Mr. Sen appeared. Clear arbitrariness, where to frustrate the entire tender process, they shifted the entire location of the project. You see, but even in that thing, the court did not interfere because so maybe in the best in public interest. But then damages were
My lord, this
given
is
to
not
the,
a case where
that does not come close to there also. In that case, they were settled with the contract and it was frustrated after that. You should look, there's a judge. Anyway, we'll pass orders. Yes. Yeah.
just
My
one thing,
counter
my lord.
affidavit, Lordship, I have just one
Yes.
moment. I won't.
Where's the
take
counter
long.
affidavit?
In my counter affidavit, your Lordship will find that I've set out these propositions and the relevant.
Lord, number
portion
of
all the
judgments have been
I
quoted
Where?
in the entire affidavit in opposition. In fact, in almost all the paragraphs,
Yes.
there are judgments only which have been quoted.
NG projects.
Number of only judgments and judgments are there. NG projects is there. Then again, Lord, it's
Uflex
complete
is
quotation. Complete quotation, my lord.
Like a digest
Galaxy
of,
Transport
like a
Agencies,
Afcons is there.
and then
Yes,
Uflex
Shilpi
Limited.
Constructions is
Lordship
there.
will see
It's just a quotation and quotation, my lord. Honestly speaking.
as the government, it becomes slightly difficult because, for instance, if I was a private contractor, no such remedy would lie. And that is the theory that the Honorable Supreme Court is now applying. That only because you are a public employer, you should in
No,
contractual
the thing is that
matters,
here, see,
that writ
we can even
petitions-
understand, like, arbitrariness if somehow, like, a contractual, like, relationship, has come out somehow, where, like, is sort of frustrated, on extraneous considerations. So even though, like, remedy requires private law, but sometimes court will interfere to the extent of arbitrariness.
Yes.
But in this case, it has not come to that stage. You understand? Like, it's come to a stage where you are in anticipation. You're the only bidder. You said yes, like
Not the only bidder, my lord.
he said
Qualified,
it's already in my
qualified
hand.
bidder.
Qualified bidder, yes. But then it's taken away. But then the reasons given that on 58, 59.9 is not mandatory. It's like may.
May, my lord.
May,
But,
like, that gives
but
them, since the owners of the project, they have all the right, to maybe seek, a better deal.
The only contradiction that I would make to Mr. Sahai's statement here, my lord, is Mr. Sahai stated that 5.59 would come into force when there would be 2-3 people who have qualified in the technical stage, and then it is awarded to a particular
It's
bidder.
not that. Even if one bidder was there, then if the challenge was made, that how are you given only one bidder, then if he was technically competent, the price was competitive, and the other conditions, then that's the reason given. That also we will not really go into that. But the thing is that only your legally enforceable right, they have a right to,
It's on my basis, my lord, is on the regulations, my lord. Because
no regulation.
Because, my lord, the regulations they themselves have adopted, and they themselves have stated in the NIT that it will be done through the National Open Competitive Procurement as specified in World Bank's procurement regulations. And it is the same regulations which I am relying upon. That is my only humble submission, my lord.
Okay, then take down.
My lord.
I think we can. The petitioner, who is stated to be a joint venture had participated in a tender process initiated this is an actual one, correct? By RFB, like request for bids.
Lord, if I may just interrupt for a moment.
Yes.
Lord, there is one matter which is coming up. If your lordship could excuse me just for 2 minutes, my lord.
Yes, you don't have anybody, but then how do you know orders?
My lord, I'll be back within 2 minutes, my lord.
Okay. Tom.
Petitioner was stated to be a joint venture had participated in the tender process initiated by RFP.
Yes, in August 2022 for rehabilitation and improvement of basic facilities, improvement I capital, B basic capital, facilities small f, of Mintadu MYNTDU, Leshka LESHKA, Stage 1 in West Jayante Hills District under a package on loans to be availed from the World Bank. Stop. So the petitioner's case is that he is the sole successful bidder on the opening of the technical bids, which was conducted on 13/1/2023. But before the tender process could be completed, the same was cancelled by the impugned letter dated 1/5/2023. So, where are 1/5/2023? Wherein the respondent corporation, Tom, show that.
The petitioner cases that he is a sole successful bidder on the opening of the technical bids, which was conducted on 13/1/2023. But before the tender process could be completed, the same was cancelled by the impugned letter dated 1/5/2023, wherein the respondent's corporation.
Wherein the which not wherein which was communicated to the petitioner. Next paragraph. Being aggrieved thereby, the incident petition has been filed. From the it has been contended that the conditions as prescribed where's that page? 566. This is one document from page 16 to 566.
Yes, Your Lordship. One document.
The conditions which are prescribed in the RFB.
I apologize, Your Lordship. This document starts at 554. These are the procurement regulations.
Okay.
For IPF borrowers. 554.
So I'm moved then.
Being aggrieved thereby, the extent petition has been filed, so
At 566.
contended by the Commission as prescribed
In the RB, in the procurement regulations. For IPF borrowers under the World Bank has been violated in denying, in cancelling tender process, which has resulted in the deprivation of the writ petitioner from being a successful bidder in the said contract. The attention of this court has been drawn by Ms. P. Agarwal, learned counsel for the petitioner, to clause 558, 5.58 and 5.59 under the caption the capital rejection of bids stroke proposals. Stop. It has been So stop. Great stress has been laid upon clause 5.59 to advance the case of the petitioner inasmuch as is submitted. It has been given therein that the lack of competition shall not be determined solely on the basis of the number of bidders stroke proposers, and that even when only one bid or proposal has been submitted, the process may be considered valid if certain other conditions are met. It is therefore submitted that the stipulations as contained in 554. Is 554 correct? 55? It starts in the statement as contained in the regulation, in the procurement regulations having been met, the respondent corporation, by cancelling the tender process, has acted arbitrarily and illegally. Stop. They therefore prayed that the respondent corporation be directed to complete the tender process to its logical conclusion. Stop. Next paragraph. On behalf of the respondent corporation, a question has been raised as to the possession of any legally enforceable right on the part of the writ petitioner, on the grounds that amongst other grounds is that the matter concerns a commercial transaction, and that the respondent corporation, being the proponent of the project or the owner thereof, is the most competent authority to decide on its own requirements as to its satisfactory execution. Stop. Mr. S. Sahai, on the pointed grounds raised by the petitioner, has also referred to clause 5.59 and submits that this, in fact, is not mandatory, but is an escape clause in the event that a single bid is received and the same is found to meet the other requirements as given in A, B, and C of clause 5.59. 5.59. Stop. He further submits that this aspect being solely within the discretion of the respondent corporation, the suspension or cancellation of the tender process is solely its prerogative, depending on the facts and circumstances of the matter. Stop. Any other submission? A reference has also been made to, you want to quote the judgments or not necessary? You want to quote the judgments or it's not necessary? Yes? Reference also been made to recent judgments of the Honorable Supreme Court wherein
Lordship, the scope of tender jurisdiction has been whittled down.
yes, wherein he was Homer,
Reference has also been made to a recent judgment of the Honorable Supreme Court
wherein tender jurisdiction and interference by courts in exercise of powers under writ jurisdiction have been significantly whittled down. WHITTLED. Stop. In this context, reliance has been placed on a decision of UFLEX Limited versus State of Tamil Nadu, reported in 2022, in brackets 1 SEC 165, apart from other judgments which have been detailed in the affidavit, which includes NG Projects Limited, NG and Stop G Stop Projects Limited versus Vinod Kumar Jain, 2022, within brackets 6 SEC 127. Stop. He therefore submits that the petitioner, having been made out any case for the violation of any fundamental or legal right, and the writ petition deserves no consideration, and the same is liable to be dismissed. That's it.
No mandamus can be issued on.
Yes, and that no mandamus can be issued directing for completion of the tender process. Stop. Having heard and consulted with the parties and having examined the materials of record, it is noted that the crux of the matter lies in the claim of the petitioner to legitimate expectation for conclusion of the tender process, which is contained in the, where is that, 566, which is contained in the
IPF regulations
in the procurement provisions under the heading stroke caption of rejection of bids stroke proposals. Stop. For easy reference, the set two clauses, namely 5.58 and 5.59, are reproduced herein below. I'll flag it. Next paragraph. Approval of the above noted clauses has described the situations which the owner of the project may resort to in certain situations as given thereunder. Stop. It is noted that clause 5.59 especially has given the project proponent the latitude and discretion to decide on matters as given the said clause. So, detailed examination of this clause indicates that the detailed examination of the clause in the opinion of this court indicates that a lack of competition as given in 5.58A, clause A, bracket A, is not to be determined solely on the basis of the number of bidders, and that the same may be considered if the conditions contained in 5.59, the bracket A, B, and C are satisfactorily met. So, the stipulation, therefore, it can be clearly seen, has been given in furtherance of the discretionary powers that are vested with the owner of the project, as also the matters of prescribing specific tender specifications. So, in this view of the matter, therefore, the submission as advanced by the counsel for the petitioner that the petitioner, being the sole bidder, it is incumbent upon the respondent corporation to accept the bid and complete the tender process, cannot be accepted. Stop. Next paragraph. Further is noted that this being only the limited point in issue, no other legally enforceable right has been made out by the petitioner to warrant any interference by this court at this stage. Stop. However, as has been apprised to this court by the counsel for respondent corporation, that the project is still to be restarted. The process of the still started. The writ petitioner, therefore, will naturally be allowed to take part in any other process without prejudice to the proceedings that have been brought before this court. Stop. For the foregoing reasons, as aforementioned, stop this petition. No interference between is disposed of accordingly. Yes.
Obliged, my lord. Lord, just one humble prayer in
Yes.
item number 14, my lord. Your lordship had directed to be listed after 1 week. I just realized that the puja at our residence is starting from 15.
You tell the court master.
If it could be after puja vacation, my
Tell
lord.
the court master. Yes. If Dr. Mozika was here, I would have been disposed of also.
Yes, my lord.
Yes. Few over
Great.